If you can get through these 30 most missed real estate exam questions, you are practicing the patterns that usually decide. Pause each question, choose A, B, C, or D, then watch the answer and the trap breakdown. Keep next block. Agency representation. These are high miss question. Question E. New York requires disclosure of agency relationship. Your choices are A, only at closing, B. The correct answer is B, at first substantive contact. NY law requires disclosure at first substantive contact about a specific property. Here is the trap. Students wait for a contract or closing. New York 1. Question R. A buyer's agent in New York owes the seller. Your choices are A, fiduciary duties, B, the correct answer is B, honest and fair dealing. A buyer's agent owes the seller honest and fair dealing, but fiduciary duties go to the buyer. Here is the trap. Fair dealing is not the same thing as fiduciary loyalty. Question 3. A New York dual agent must have. Your choices are A, verbal consent from one party, B, the correct answer is B, informed written consent from both parties. Dual agency requires informed written consent from both buyer and seller. Here is the trap. Verbal consent is not enough when both sides are represented. Question 4. A New York broker's fiduciary duties include all except. Your choices are A, loyalty, B, the correct answer is C, guaranteeing sale price. Brokers cannot guarantee outcomes. Duties include loyalty, disclosure, confidentiality. Here is the trap. The exam mixes real duties with promises brokers can never get. Question 5. From whom does a real estate salesperson receive their compensation in New York? Your choices are A. The correct answer is D, the sponsoring broker. In New York, salespersons receive compensation only from their sponsoring broker, not directly from client. Here is the trap. Salespersons do not collect commissions directly from clients. In next block. Ownership contract basics. These are high miss question 0. A New York condominium differs from a cooperative because. Your choices are A, condos are less. The correct answer is B, condo owners have a deed to their unit. Condo owners receive a deed to their unit. Real property, co-op owners hold shares. Here is the trap. Both sound like ownership, but the exam cares whether the owner holds. Question 2. The most commonly used deed in New York residential transactions is. Your choices are A, quitclaim. The correct answer is B, bargain and sale deed with covenants. Bargain and sale deed with covenants against grantors acts as standard in NY. Here is the trap. Students often default to general warranty deed even when the state used. Question 5. New York recognizes which form of marital property ownership? Your choices are A, community property. The correct answer is B, tenancy by the entirety. NY recognizes tenancy by the entirety for married couples, providing protection from individual credit. Here is the trap. Community property is not the New York answer. Remember the question 9. In New York, a contract of sale for real property must be. Your choices are A, oral only. The correct answer is B, in writing to be enforceable. The statute of frauds requires real estate contracts to be in writing. Here is the trap. Recording and notarizing sound formal, but the core requirement. Question 10. A binder in New York real estate is. Your choices are A binding contract, B, the correct answer is B, a preliminary agreement subject to attorney approval. A binder is a preliminary agreement typically subject to attorney approval within 3-5. Here is the trap. Students hear binder and assume a final contract. Next block. Financing foreclosure. These are high miss question 11. New York uses which security instrument for real estate loans? Your choices are A. Deed of trust. The correct answer is B. Mortgage. New York is a mortgage lien theory state. Here is the trap. Deed of trust is common elsewhere, but not the New York answer. Question 12. Foreclosure in New York is. Your choices are A. None. Judicial by power of sale. B. The correct answer is B. Judicial through the court system. New York requires judicial foreclosure through the court system. Here is the trap. Students mix judicial and non-judicial systems from Question 13. In New York, CEMA, Consolidation Extension and Modification Agreement, is used to. The correct answer is B. Reduce mortgage recording tax on refinancing. CEMA allows borrowers to pay recording tax only on the new money borrowed when refinancing. Here is the trap. The acronym sounds technical, but the test is really about Question 14. A New York borrower has the right to redeem property. Your choices are A. For 2 months after sale. The correct answer is B. Until the foreclosure sale is confirmed. And why borrowers can redeem until the court confirms the foreclosure sale. Here is the trap. Many students assume there is a fixed post-sale redemption. Question 15. New York's mortgage recording tax is approximately. Your choices are A. 0.5% of the mortgage. The correct answer is C. 1.8% to 2.8% depending on location. And why mortgage recording tax varies by location, ranging from about. Here is the trap. The exact number shifts by location, so the exam usual. Next block. Formation essentials. These are high-miss questions with question 16. Which of the following is required for a valid contract in California? Your choices are A witness. The correct answer is C. Mutual consent. A valid contract requires competent parties, mutual consent, offer and acceptance, lawful. Here is the trap. Students often default to formalities like notarization or record. Question 17. The statute of frauds requires that. Your choices are A. All contracts must be notarized. The correct answer is B. Real estate contracts must be in writing to be enforceable. The statute of frauds requires certain contracts, including those for the sale. Here is the trap. The exam likes to test whether you know writing is about enforceability. Question 18. What constitutes consideration in a real estate contract? Your choices are A. Money only. B. The correct answer is D. Money, work, or a promise. Consideration can be money, services, goods, or a promise, anything of value. Here is the trap. Students make consideration too narrow and think only cash counts. Question 19. A purchase offer becomes a binding contract when signed by. Your choices are A. Buyer only. The correct answer is D. Buyer and seller. A purchase offer becomes a binding contract when both the buyer and seller have signed, creating mutual agreement. Here is the trap. One signature is not enough. The contract binds when. Question 20. A seller rejecting an offer, changing terms, and resubmitting creates. Your choices are A. The correct answer is A. Counteroffer. A counteroffer is a rejection of the original offer combined with a new offer on different terms. The original offer is term. Here is the trap. Changing terms is not a harmless edit. It kills the next block. Contract types and conditions. These are high-miss. Question 21. A bilateral contract is one in which. Your choices are A. Only one party makes a promise. The correct answer is B. Both parties make promises to each other. In a bilateral contract, both parties exchange promises. A sales contract. Here is the trap. Students hear contract and think writing requirement instead of question 22. An option contract in Michigan gives the buyer. Your choices are A. Ownership of the property. The correct answer is B. The right, but not obligation, to purchase within a specified time. An option contract gives the buyer the right, but not the obligation. Here is the trap. An option does not transfer ownership. It only gives. Question 23. The difference between a lease option and lease purchases. Your choices are A. Lease option obligate. The correct answer is A. Lease option obligates seller only. In a lease option, the seller is obligated to sell if the buyer exercises the option, but here is the trap. Both sound like rent, to own, but the buyer is not. Question 24. Contracts with contingency clauses are. Your choices are A. Voidable, B. Valid. The correct answer is A. Voidable. Contracts with contingencies are voidable because either party may void the contract if the contingency is not met, e.g., here is the trap. Students treat contingencies like automatic void contracts when the. Question 25. A Missouri land installment contract, contract for deed. Your choices are A. Is prohibit. The correct answer is B. Is regulated with buyer protections. Missouri regulates land installment contracts to provide protections for buyers. Here is the trap. Installment contracts are not the same as immediate title transfer. Next block. Breach and enforceability. These are high-miss questions. Question 26. A court remedy compelling a party to complete a property sale is. Your choices are A. Execution. The correct answer is C. Specific performance. Specific performance is a court order requiring a party to fulfill their contractual obligations. Commonly here is the trap. Because real estate is unique, contract remedies are not just. Question 27. The seller dies after an offer to purchase their property has been accepted. The seller's grandchild inherits. The correct answer is B. The grandchild is compelled to sell under the terms of the accepted offer. An accepted offer creates a binding contract that survives the death. Here is the trap. Students think death automatically destroys the deal. The. Question 28. An as-is clause in a general purchase contract. Your choices are A. Applies only to matters of. The correct answer is B. Applies only to things that have been properly disclosed or are visible and observable conditions. An as-is clause transfers property without. Here is the trap. As-is does not erase disclosure duties or magically wipe. Question 29. A contract signed by a minor is. Your choices are A. Invalid, B. Valid. The correct answer is C. Voidable. Contracts signed by minors are voidable, meaning the minor can choose to void the contract or ratify it upon reaching the age. Here is the trap. Minors do not always create totally void contracts. Question 30. An offer to purchase real estate is terminated by all of the following except. Your choices are A. Death. The correct answer is C. Inquiry about terms by the offeree. An inquiry about terms does not terminate an offer. However, death of the offerer. A. Here is the trap. An inquiry about terms feels like a rejection, but it is not. Comment how many you got right out of 30. If you scored above 24, you are in strong shape. If one topic kept costing you points, make that your next